A federal courtroom just witnessed what legal analysts are calling a complete evisceration of Donald Trump's defense strategy. Judge Tanya Chutkan rejected every single motion filed by Trump's legal team in a scathing 4-page ruling that dismantled their arguments point by point. And this isn't some procedural setback or minor legal loss. This is a federal judge systematically destroying the entire foundation of a defense strategy that Trump's attorneys spent 7 months constructing. When a federal district judge uses phrases like legally frivolous and factually unsupported in an official ruling, the legal walls just closed in dramatically. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what triggered this devastating judicial rebuke? According to court documents filed on January 9th, Trump's legal team had submitted 8 separate motions seeking to dismiss charges and exclude evidence and delay trial proceedings. The motions argued presidential immunity, selective prosecution, violations of Trump's First Amendment rights, and claims that the indictment was politically motivated. Judge Chutkan spent 3 hours in open court on January 8th hearing oral arguments before issuing her written ruling the following morning. This isn't just another legal dispute or routine motion practice. This is a federal judge concluding that defense arguments lack any credible legal basis and appear designed primarily to delay rather than to present legitimate constitutional claims. And believe me, when a federal judge issues a 4-page opinion systematically rejecting every argument your legal team presents, the implications for your case are catastrophic. Here's the full picture of what's been unfolding. Tensions in the federal courthouse in Washington have been building since August 2025, when Trump's defense team filed their first round of pre-trial motions. But everything escalated on December 18th, when prosecutors filed a 187-page response, systematically refuting each defense claim with citations to Supreme Court precedent, circuit court rulings, and established constitutional law. The January 8th hearing drew intense media attention as Trump's lead attorney, John Lauro, presented what he called decisive constitutional arguments for dismissal. He argued that prosecuting a former president for actions taken while in office violated separation of powers, that the charges criminalized protected political speech, and that the timing of the indictment demonstrated selective prosecution designed to interfere with the upcoming election. Judge Chutkan listened without visible reaction for nearly 90 minutes before prosecutors began their rebuttal. Smash that like button if this is making sense so far. Here's where it really gets serious. When Judge Chutkan began questioning Trump's attorneys directly about the legal basis for their immunity claims, the exchange became increasingly tense. Court observers noted that she repeatedly asked for specific case citations supporting their broad assertions of presidential immunity from criminal prosecution. After the third request for legal authority, Trump's attorneys cited Nixon versus Fitzgerald, a 1982 case about civil liability. Judge Chutkan immediately pointed out that the case explicitly addressed civil suits, not criminal prosecution, and asked whether counsel had any authority directly on point for criminal immunity. The courtroom fell silent as the attorney admitted no Supreme Court case had directly addressed post-presidency criminal prosecution. And let's be honest for a moment. Federal judges issuing comprehensive rejections of defense motions are not routine occurrences in high-profile cases. They happen when judges conclude that legal arguments are not just weak, but fundamentally misunderstand or misrepresent established law. Here's what multiple sources say happened next. On January 9th at 9:47 in the morning, the clerk's office posted Judge Chutkan's 4-page opinion to the public docket. Legal reporters immediately began analyzing what they described as an unusually forceful rejection of defense claims. The opinion addressed each of the 8 motions in separate sections, devoting between 8 and 15 pages to explaining why each argument failed as a matter of law, the most devastating section addressed the presidential immunity claim. Judge Chutkan wrote that the defendant's assertion of absolute immunity from criminal prosecution for acts committed while president is without any support in the constitutional text, the historical record, or Supreme Court precedent. She continued that accepting such a sweeping immunity claim would place presidents above the law and create a system where the most powerful official in the government faces the least accountability. Sources who reviewed the opinion noted that Judge Chutkan cited 47 different cases and quoted extensively from Federalist Papers' discussions of executive accountability. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely devastating for Trump's legal position. The opinion systematically dismantled the selective prosecution argument by noting that Trump's legal team failed to provide any evidence that similarly situated individuals were not prosecuted. Judge Chutkan wrote that speculation and conjecture about prosecutorial motives cannot substitute for evidence, and that the defendant has not identified a single individual who engaged in comparable conduct and was not charged. Court watchers described this section as particularly damaging because it exposed that Trump's attorneys made sweeping accusations without supporting factual foundation. That's when it became clear this isn't just a setback, but a wholesale rejection of the defense strategy. The bombshell moment came in the section addressing First Amendment claims. Judge Chutkan wrote that while political speech enjoys robust constitutional protection, the First Amendment does not provide cover for criminal conduct simply because that conduct involves speech. She continued that accepting the defendant's theory would mean that anyone could escape liability for fraud, solicitation of crimes, or conspiracy simply by characterizing their words as political speech. Legal analysts reviewing the opinion said this language essentially foreclosed any First Amendment defense at trial. This move sent shockwaves through legal circles and significantly altered the trajectory of the prosecution. When a federal judge not only rejects defense motions but uses language suggesting those motions border on frivolous, it signals to appellate courts that any future appeals from this judge's rulings should be viewed with skepticism. The credibility of Trump's legal team took a severe hit when their carefully constructed constitutional arguments were dismissed as lacking any support in law or precedent. This isn't the first time a federal judge has issued a comprehensive rejection of attempts to claim immunity from prosecution. Think back to United States versus Nixon in 1974. President Nixon claimed executive privilege allowed him to refuse to provide tape recordings subpoenaed by the Watergate special prosecutor. The Supreme Court unanimously rejected that claim, holding that while executive privilege exists, it does not extend to shield evidence of criminal conduct from judicial process. Nixon was forced to turn over the tapes, which proved his involvement in the cover-up and led directly to his resignation. 8 days later, then there was Clinton versus Jones in 1997. President Bill Clinton argued that sitting presidents should be immune from civil litigation for actions unrelated to their official duties. The Supreme Court unanimously rejected that argument, holding that the president is subject to the laws for purely private conduct. While Clinton remained in office, the case established that presidents do not enjoy blanket immunity even while serving. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget the more recent battles over congressional subpoenas and financial records. Trump's attorneys argued repeatedly that Congress lacked authority to investigate a sitting president and that presidential records were absolutely privileged. Federal courts rejected those claims in case after case, establishing that presidents cannot simply refuse to comply with legal obligations by asserting broad immunity claims. Now, however, the rejection is even more comprehensive. This time, a federal judge has systematically addressed and rejected 8 separate legal theories in a single ruling, each one dismantled with extensive legal analysis showing why the arguments fail. The pattern is clear. When presidents or former presidents attempt to claim immunity from legal accountability, federal courts consistently reject those claims and reaffirm that no one, regardless of position, stands above the law. So what legal principles drove this unprecedented judicial rebuke? According to constitutional law experts who analyzed Judge Chutkan's opinion, her ruling rests on fundamental principles about the rule of law and constitutional structure. The opinion emphasizes that the Constitution's text contains no grant of immunity from criminal prosecution for presidents or former presidents, and that the framers explicitly rejected proposals that would have granted such immunity, and that the structure of our constitutional system depends on the principle that powerful officials remain accountable to law. Here's the kicker. Judge Chutkan's opinion includes a detailed historical analysis showing that the framers specifically considered and rejected versions of the Constitution that would have provided presidents with immunity from prosecution. She quotes from the Constitutional Convention debates, where delegates discussed whether presidents should face criminal liability, and concludes that the historical record demonstrates the framers intended presidents to remain subject to ordinary criminal law. This wasn't a cursory analysis of constitutional history. It was a thorough examination of founding-era documents that directly contradicts the defense team's historical claims. Don't go anywhere. The most explosive part is coming next, and here's what should alarm Trump's legal team about the broader implications. This opinion doesn't just reject their current motions, it forecloses entire categories of arguments they might have raised. Later in the proceedings, by comprehensively addressing immunity, selective prosecution, First Amendment defenses, and political motivation claims all in one ruling, Judge Chutkan has essentially told the defense that these theories will not provide any basis for dismissal, exclusion of evidence, or jury instructions at trial. The defense strategy has been stripped down to its foundation before trial even begins. This puts Trump in a nearly impossible position heading toward trial. On one side, he faces a federal judge who has now signaled in the strongest possible terms that constitutional defenses will not succeed in her courtroom. That means the trial will focus on the factual question of whether Trump committed the charged acts, not on whether those acts can be excused by presidential status or political context. On the other side, he faces prosecutors who now have a 94-page judicial opinion, and they can cite to shut down defense arguments before they fully develop every time Trump's attorneys attempt to raise immunity or First Amendment issues. Prosecutors will point to Judge Chutkan's comprehensive rejection of those theories, and here's the tricky part. There's no viable path to overturn this ruling before trial. Trump's team can appeal to the D.C. Circuit Court of Appeals, but appellate courts give enormous deference to trial judges on legal questions, especially when those judges provide detailed analysis supporting their conclusions. Appellate courts reviewing Judge Chutkan's 94-page opinion with 47 case citations and extensive historical analysis will find it difficult to conclude she committed legal error. Even if they disagree with some aspects, they're unlikely to reverse wholesale when the opinion demonstrates careful consideration of the legal issues. Legal and political analysts are calling this a turning point in the prosecution. Randall Eliason, a George Washington University law professor and former federal prosecutor, told news outlets that Judge Chutkan's opinion eliminates the legal fog that defense attorneys typically use to create doubt about prosecution theories. He explained that by comprehensively rejecting constitutional defenses before trial, the judge has ensured that the jury will focus on the actual evidence of what Trump did rather than being distracted by abstract legal theories about presidential power. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even Alan Dershowitz, a prominent defense attorney who has defended Trump in previous proceedings, acknowledged that Judge Chutkan's legal analysis is thorough and difficult to challenge on appeal. He stated that while he disagrees with some of her constitutional conclusions, she has provided extensive legal reasoning that appellate courts will be reluctant to overturn. He emphasized that Trump's best hope now lies in convincing a jury of his factual innocence rather than in prevailing on constitutional immunity theories. So let's break down what this could mean. First, the immediate impact on trial preparation is profound. Trump's legal team spent 7 months developing constitutional arguments that would have allowed them to challenge the charges without disputing the underlying facts. Those arguments have now been comprehensively rejected, and this forces a complete strategic pivot. Instead of arguing that Trump's conduct was protected by presidential immunity or the First Amendment, his attorneys must now convince a jury that the conduct never occurred or that prosecutors have misinterpreted the facts. That is an infinitely more difficult task when the evidence includes recorded phone calls, documentary evidence, and witness testimony from Trump's own advisors. Second, this ruling significantly increases the likelihood that Trump will face trial before the election. Defense attorneys typically delay trials by filing multiple pretrial motions, appealing adverse rulings, and raising constitutional issues that require appellate resolution before proceedings can continue. Judge Chutkan's comprehensive ruling eliminates most of those delay tactics by addressing all major constitutional defenses in a single opinion. While Trump can still appeal, appellate courts reviewing such a detailed ruling will be unlikely to grant stays of trial proceedings while appeals are pending. Trial could now begin as early as March or April 2026. Finally, the political implications heading into the election season are dramatic. Trump has consistently told supporters that the charges against him are politically motivated attacks that violate his constitutional rights. Judge Chutkan's opinion systematically refutes each element of that narrative. When a federal judge appointed by a Democratic president issues a 9-4-page opinion explaining in meticulous detail why immunity claims fail under law and historical precedent, it becomes much harder to maintain that the prosecution is simply political persecution. Moderate voters who might have been sympathetic to constitutional arguments will now see those arguments were thoroughly considered and rejected by a federal judge and applying established legal principles. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate legal fallout, this is really about fundamental constitutional principles. And the concept of presidential immunity from criminal prosecution represents one of the most significant questions in American constitutional law. If former presidents cannot face criminal charges for conduct committed while in office, it creates a dangerous precedent where the most powerful official in government faces the least accountability. Judge Chutkan's opinion emphasizes that such a system would be antithetical to founding principles and constitutional structure if presidents know they can never face criminal prosecution for official acts. The incentives for abuse of power become overwhelming. The rule of law depends on the principle that everyone, regardless of power or position, remains subject to legal accountability. This scenario is causing intense concern within Trump's legal team and political operation. Reports indicate that Trump's attorneys held emergency strategy sessions over the weekend trying to determine how to proceed. After such a comprehensive defeat, some argued for immediately appealing to the D.C. Circuit despite the likelihood of losing, primarily to buy time and delay trial. Others insisted that focusing resources on trial preparation made more sense than pouring money into appeals with little chance of success. The internal debate reflects a legal team that has just seen its entire constitutional strategy dismantled and must now fundamentally rethink its approach. Meanwhile, Trump supporters are expressing fury at Judge Chutkan, claiming her ruling proves judicial bias and political motivation. Social media platforms are flooded with attacks on the judge and calls for her recusal or impeachment. Conservative legal commentators are arguing that the opinion reflects hostility toward Trump rather than neutral application of law. Trump himself has amplified these attacks, posting that Judge Chutkan is a radical Democratic activist who has prejudged the case and should be removed. Things escalated further when Trump issued a lengthy statement through his legal team, and they're on social media calling Judge Chutkan's ruling a politically motivated hit job designed to interfere with his presidential campaign. The statement claimed that the opinion ignores clear constitutional protections for presidents and represents the latest chapter in a multi-year witch hunt. Trump specifically attacked Judge Chutkan's legal reasoning, claiming she deliberately misread precedent and ignored historical evidence supporting presidential immunity. Stay with me. What comes next will completely change how you view the situation. Here's what makes Trump's response even more problematic from a legal standpoint. Publicly attacking a federal judge who will preside over your trial is extraordinarily risky. Judges have broad discretion in managing trials, ruling on evidence, and instructing juries. When a defendant launches personal attacks on the judge's integrity and accuses that judge of political bias, it creates a hostile dynamic that can influence countless discretionary rulings throughout trial. Legal experts watching this unfold note that Trump's response, while potentially satisfying to his political base, could have devastating consequences when his attorneys appear before Judge Chutkan seeking favorable rulings on evidentiary issues or jury instructions. Legal experts immediately flagged this as a strategic disaster. Jennifer Rogers, a former federal prosecutor and CNN legal analyst, explained that attacking judges publicly tends to backfire because it suggests desperation and lack of confidence in legal arguments. She noted that when defense teams have strong legal positions, they appeal through proper channels using legal briefing rather than launching public relations campaigns against judges. The fact that Trump's response focused entirely on attacking the judge rather than identifying specific legal errors in her analysis suggests that his legal team recognizes the opinion is legally sound, even if politically damaging. This goes far beyond one ruling in one case. It's about whether former presidents can use claims of immunity to avoid accountability for criminal conduct committed while in office. If constitutional defenses based on presidential status were allowed to succeed without rigorous legal scrutiny, it would establish that the presidency confers effective immunity from prosecution regardless of the severity of alleged crimes. Judge Chutkan's opinion makes clear that federal courts will not allow presidential status to function as a get-out-of-jail-free card when former presidents face serious criminal charges. If this blows your mind, hit that like button right now. Here's the situation. A federal district judge just issued a 94-page opinion systematically rejecting every constitutional defense argument that Trump's legal team spent 7 months developing. The opinion dismantles claims of presidential immunity, selective prosecution, First Amendment protection, and political motivation. This is no longer about constitutional theory or abstract legal questions. It's about whether Trump can convince a jury that the factual allegations against him are false because his legal defenses based on presidential status have been comprehensively rejected. When a federal judge writes that immunity claims are without any support in constitutional text, historical record, or Supreme Court precedent, and backs that conclusion with 47 case citations and detailed historical analysis, we've entered a new phase where constitutional defenses will not provide any protection. If appellate courts affirm this ruling, it establishes binding precedent that former presidents face criminal accountability for conduct committed while in office. Keep a close eye on this story. Trump's legal team has 14 days to file a notice of appeal to the D.C. Circuit Court of Appeals. Appellate briefing will take approximately 60 days, followed by oral argument and a decision. But Judge Chutkan has made clear that trial preparation will continue regardless of any appeals, meaning Trump could face trial even if appellate proceedings are still pending. And legal experts across the political spectrum are watching closely to see whether appellate courts affirm Judge Chutkan's comprehensive rejection of presidential immunity from prosecution. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. Trump's entire legal defense strategy has been dismantled by a federal judge who spent 94 pages explaining precisely why constitutional arguments fail under established law and historical precedent. His legal team must now pivot from constitutional defenses to factual disputes about whether the charged conduct occurred. Meanwhile, prosecutors have a comprehensive judicial opinion they can cite to shut down any attempt to revive immunity or First Amendment arguments. This isn't just another news cycle that will fade away. This is a legal foundation crumbling in real time. What happens next could determine whether any former president can ever use immunity claims to avoid criminal prosecution, or whether constitutional accountability applies equally regardless of how much power someone once held. The legal analysis is documented in 94 pages with 47 case citations. The constitutional defenses have been systematically rejected. Now we wait to see if appellate courts affirm that no one, not even former presidents, stands above the law when facing criminal charges for conduct committed while in office. The stakes have never been higher, the legal analysis has never been more thorough, and the courtroom reckoning has never been more inevitable. Pause for a second and hit that like button if you're finding value in this coverage.